Hi everybody, welcome to the practical application of the new commercial regulation webinar. We've just got everybody joining us online now, so we'll just give everybody a few minutes before we actually get started. I'd like to introduce and thank very much our two panellists, Tim McKibbin, who's the CEO of REI NSW, and Linda Rudd, who is the partner and national head of asset management services at Knight Frank. Thanks so much for joining us, guys.
Pleasure.
So the numbers are, we've got about 100 people online. I know we're waiting for a few more, so we'll just wait for a few more minutes before we actually get started. How are all of the team finding things out there in the field at the moment, Linda?
They are doing a brilliant job, Leanne. I'm particularly proud of my Knight Frank team, some of whom are dialing in today. So I will send a shout out and a very big thank you for the hard work that they are doing.
Oh, that's awesome. Yes, it's hell of a time to be a commercial property or asset manager, right?
Yeah, and look, throughout any year, we're usually pretty busy as it is, but now more so than ever, our clients are relying on us for support, and I guess that's what we're here for.
Yeah, that's exactly right, exactly right. And it's also nice to see, you know, as a leader, it's really nice to see when your team members sort of step up and actually provide that level of service that is over and above what you can even reasonably expect, particularly in stressful times. So that's great.
Yeah, I agree. And you know what, even some of our clients have really reached out to our team and just showed some recognition and some thanks and you know, for all the help and assistance that they are providing, because everyone's in this together. We're trying to navigate the regulation and the code and the changes and COVID and building operations, etc. So it's been actually a tough period, but admirable in terms of the way everyone's handled it.
Yeah, that's awesome. And Tim, how the team at the REI are also doing an incredible job. The communication.
Yeah, they are. It's been amazing, really, and just having to everybody virtually, we snapped our fingers and we all had to go home. So
yeah, you really did. It did happen all very last minute for you guys, didn't it? It was like all of a sudden, actually, yeah, we need to be home now.
Yeah, and well, I think it happened to a lot of businesses that, you know, 1 minute we're in the office and people were saying that that's acceptable, and then all of a sudden it wasn't. So then, you know, people had to go home. So there was technology issues to sort out, and you know, a whole raft of things about people who would normally interact with one another. You know, at a one-on-one basis, face-to-face. So all of those had to be rethought. Having said that, and hanging around agents now for so long, Leanne, rather than with lawyers where we all look on the black side, it's I think that there is a positive coming out of it, and that is that, you know, I think we've proved to ourselves that we can work effectively from home and use technology as we are now, and so I think we'll be a different workforce, you know, right across the nation now.
Oh, look, I think there's no doubt. Yeah, there's no doubt. We've certainly, we will certainly change the way we meet with our franchisees. I mean, we've talked about the fact that we'll change the way the REI board meets. So lots of things will change. Okay, I think we're probably ready to start. So the way we're going to manage this, guys, is Linda's going to run through the presentation. We've already got some questions that we want to ask, but if you do have a question, you know, you can just put it into the Q&A at the bottom, and we will get to as many of them as we possibly can. So Linda, over to you.
Okay, cool. Thank you very much, Leanne. I'll try and answer all the questions to the best of my ability.
Okay.
Look, just a quick intro. So I'm partner and national head of asset management services at Knight Frank Australia. So we manage approximately 4.5 million square metres or over of office, retail and industrial space. I've worked in the industry for 16 years, both in Australia and the UK. I have a 400-strong workforce of property managers, facilities managers and accountants, all working very hard at the moment as we address the situation that Corona presents itself. So look, I do just want to make a point that for anything we talk about today, you should make sure that you seek legal advice either for yourself as a landlord or your landlord solicitors as a property manager or property representative. Okay, I'm going to jump straight into it. So what do we know? The regulation, it was drafted quickly. So I guess we've quickly drafted legislation, it can lead to flaws. All laws can have flaws, but certainly we need to figure out how we navigate this with what we know. It is ambiguous in parts. It presents more questions than it does answers in some areas. It does need to be applied to impacted tenants. Non-impacted tenants, we can negotiate. I will just caveat that there is a bit of conjecture about the definition of commercial leases, whether that applies across all commercial leases or, again, just the impacted tenants. There's been some information in the papers about that. This regulation does take effect from the 24th of April this year. It is not retrospective, but I'll come on to that in a little bit. State government has allocated an extra 10 million in funding for the New South Wales Small Business Commissioner for mediation services. So I think they anticipate that this is going to get a little bit litigious and there could be some dispute. And so hence have allocated some extra resources. And mediation is intended to be fair and without bias to one party or another. So, you know, all parties should enter mediation in good faith as well. That is a word I'll use quite frequently, good faith, because that is the intention of the operation of the regulation, the code, and certainly the correspondence and communication between landlord and tenant. And again, at all times, and given the above, you should seek legal advice if you need clarification. Okay, so just some key points. So prescribed actions is listed as re-entering premises or locking tenants out, charging interest on unpaid rents, drawing down on bank guarantees or security deposits, enforcing personal guarantees. A prescribed period is going to be the 24th of April to the 24th of October. An impacted tenant will apply to a business tenant with turnover of less than 50 million. So the intention of the National Code was to address small to medium sized businesses and enterprise, and that experienced a 30% more reduction in revenue because of COVID. And franchise lessees, so not the franchise group. If you think about franchise structures, tends to be, say, even a mum and dad business that have bought into the franchisee locally, and they own that business under that franchise operating agreement, which can vary. So that's just probably some insight into that point. So impacted tenant information, this has sort of been quite the contentious point, and I've been hearing all sorts of feedback of, you know, tenants not wanting to provide information. It's a pretty sticky situation, or a pretty interesting position to take, given that the landlord does need to understand the impact to tenants in able to assess what relief or deferral or what kind of conditions they can try and negotiate to help. So any way a tenant can demonstrate, you know, how they are impacted is going to help the landlord assess how they can help. So what types of information can you ask for? Our teams are asking for, you know, P&L statements, turnover statements, sales information. But interestingly enough, given that an impacted tenant is deemed to be any tenant that qualifies for JobKeeper, the ATO does ask for sales and turnover information. But a comparison of sales or likely sales for a recent month with the same month last year. So particularly in retail, as an example, you'll know that, you know, we tend to experience or expect higher sales around the November-December period as people prepare for Christmas. So if you compare one period of a year to a previous period in the same year, then it should give you some insight. That's not always hard and fast. And interestingly enough, some retailers are booming in this period. I've got a bike store around the corner from me, and there's a line out the door because everyone's buying bikes, which is fantastic to see. It's good to see a local business being supported. There's other tenants that aren't doing so well, so we have to be mindful of all scenarios. But something that was actually debated yesterday in a session that we had with our team was this confirmation from the ATO that the tenant qualifies for JobKeeper. I would assume, given how diligent that the ATO is, that they should be providing something in writing from them to tenants detailing that the tenant does qualify for JobKeeper. I haven't seen an example as yet, but that's something that, you know, I do know some landlords are looking to just to hold out to see what, they're not sort of chasing rents actively. They are holding out just to sort of see if the tenant does qualify for JobKeeper. Again, something else that was debated yesterday is that we're seeing some tenants send a screenshot of their application to the ATO. That's not necessarily confirming that they are, you know, they do qualify for JobKeeper. So just be mindful of that. You know, the landlord is within their rights to ask for information. But again, I just say do so in good faith. And I think too, now more than ever, show patience to tenants. They are also going through a pretty tough period. So I think sometimes and we're working with busy property managers and busy landlords who are also dealing with it. And so that can lead to conflict. I think everyone should exercise patience and try and, you use the best kind of terms possible to try and ask for this information, as opposed to demands or or in any other kind of threatening ways. I'm sure people wouldn't be threatening, but just to kind of be mindful of different situations. Okay, so the next scenario is rent relief deferral or request. So a tenant has applied for rent relief. What should I do? Look, the first thing I would do would see if they are an impacted tenant or qualify as an impacted tenant. This isn't a hard and fast rule, and certainly we've seen some landlords, take a step even before code or regulation came out that said, no, for all of our tenants, this is what we're going to offer. Or, for all of our March, if there was March arrears, or even April billings for the 1st of April and now May, they were raising the charges but not actively chasing them whilst we sort of navigated COVID. So there isn't one hard and fast rule, but how could you approach it? If the tenant does qualify, so negotiate in good faith, document all negotiations in the event an agreement cannot be reached. So step one, offer a change in terms. This should be by way of heads of agreement or a letter, and it should allow reasonable time for the tenant to respond. So again, if they are trying to make sure they can continue to operate as a business, or even navigate JobKeeper and how to keep staff on board, be mindful that we're all kind of navigating this. So allow a reasonable time. Any agreement should be documented if you are able to reach agreement. I'm seeing various agreements in terms of by way of side letters or variations. I do recommend that appropriate legal guidance is sought in terms of documenting, any change in lease terms to ensure it can cover all bases, and also that both parties are represented. And if agreement cannot be reached, and there is a provision that says the landlord should enter negotiations, again, in good faith. So if you feel you've qualified for, or the landlord has re-entered into negotiations, has understood the tenant, you've reviewed the situation, you've tried to negotiate, still can't reach agreement, then you can refer it to mediation to then assist with agreeing. I would hope that a landlord and tenant could agree, but again, the mediation exists to help parties reach an agreement in the event it can't. And so if the tenant is not an impacted tenant, certainly, and this is where there is a bit of conjecture, that the parties can negotiate on commercial terms. So there may be a larger business just experiencing cash flow problems, and landlords have done such great work in terms of creating tenant relationships, creating properties and environments that really meet the need of the tenant as a customer, and the property as a product. So if you've got a great relationship with your tenant, and I always encourage all landlords to have, and property managers to have great relationships with tenants, just be understanding to the situation. And yes, they might not hard and fast qualify. Is there something that the landlord can do to assist the tenant just in this little period? Thinking about the longer term as well. We're all hoping that the economy kicks back up and we can all get back into offices and continue to work. And so hence, we'll come back together as landlords and tenants in property. And there's usually longer term lease terms, and hopefully we can navigate what we can just during this time. So the next scenario is rent relief and deferral request terms. So does the regulation stipulate minimums or maximums for rent referral or discount? Look, I flagged this one because there's a bit of a difference between the regulation and the code. The code does stipulate, but the regulation doesn't go so far as to stipulate. So again, it refers back to my prior question, try and reach agreement with your tenant, in good faith. If you do resort to mediation, then it's possible that the mediator might refer to the minimum terms provided by the code anyway. And certainly with some of the advocacy work that was done by both REI and PCA, some of the discussions were about looking at a minimum that landlords were willing to commit to. And so I suspect that some of this came out of that. Granted, there was also some parts in the code that I know the advocacy would have preferred was more friendly to landlords. But again, we work with what we've got now. So just bear that in mind that, should you go to mediation, they might look at this as a minimum point. So this is taken out of the leasing principles of the National Code, in particular points 3 and 4. So do bear in mind those principles in the code. They're a little bit more extensive than what I've provided here. So the regulation arrears scenarios. So this has come up quite frequently. Question being, I have a tenant that is unwilling to pay rent. What do I do? And of course, there's a pre-COVID and post-COVID scenario here. So are they an impacted tenant? If they are, was it pre-24th of the 4th and not COVID related? And I just flagged this because the regulation states it's not, or it's not intended to be retrospective. But if it is a COVID related issue, then there is possibly an avenue for the tenant not to pay rent. So just be mindful of that. And so that could be for March, say for instance. But some examples I've been provided where tenants have been struggling, you know, through the December period and January period, and unfortunately, this could be related to circumstances even related to bushfires, etc. So that's not COVID related. So the landlord is within their rights to pursue. I do flag that again, if you're looking to retain a tenant for the longer term, and certainly in occupied premises, then maybe again you can negotiate across all a payment plan that extends out or includes this period and extends out. That might include prior COVID and post-COVID arrears. Because again, all of these situations are going to be case by case. It depends on the landlord, depends on the property, depends on the tenant, depends on the amount, depends on what other obligations the landlord might otherwise be navigating themselves. So just bear that in mind. But so if you can pursue it, then you might be able to draw down on a bank guarantee. Are you going to be able to get a bank guarantee top up? Is there actually, how much is the bank guarantee for? It might only be 3 months. Most normally they're 6 months. But certainly how long is that going to carry forward for? So just have a couple of considerations in mind when you're looking to pursue a kind of more elongated payment plan might actually suffice. So if the impacted tenant is, and it's post-COVID and COVID related, then absolutely do not pursue. So those prescribed actions that I referred to earlier. So we're not applying interest, we're not pursuing, we're not sending breach notices, we're not sending 7 or 14-day letters, etc. So outgoings, another very popular question as to whether to deem outgoings as rent. So this question, does rent referral or rent relief include outgoings? Do I discount outgoings given the discount subsidy that I may or may not receive from Office of State Revenue or Government? Look, in New South Wales, certainly there's an indication that land tax will be discounted by 25%. So gross rents, obviously this is a little bit clearer. The landlord can pass it on obviously through the rents. Net rents, as you know, we recover our rental portion and also a portion for outgoings. We're not yet sure how the Office of State Revenue is going to recognise the discount. So are they going to provide it with a payment subsidy direct to landlords, or is it going to be via a discount or credit issued, which we normally pay through outgoings? Bear in mind that those outgoings are reconciled at the end of financial years or calendar years. So we're taking a conservative position on this, saying outgoing should be considered rent, and that actually if you're looking at a total discount or any kind of rent deferral or agreement with your tenant, then you should be looking to include outgoings, and whether or not you proportionately share any discount or deferral that you're otherwise looking to agree, but at a minimum include those anticipated discounts from land tax in the tenant's proportion of outgoings. If you're going to wash up at the end of the year and you do get that credit, that is passed through to the tenant, and certainly that would, in most cases and in most buildings, those accounts are audited, so that credit will be taken into account. But just be mindful that obviously you should look at both sums when you are looking to agree any terms. So just a couple of do's, and I know that there could be a couple of questions which I'll try and answer as much as I can. So the do's, so ensure you are being, you and the lessor as a property manager or owner are entering negotiations in good faith. So again, that's ensuring all correspondence with tenants is documented, includes formal letters outlining any proposed terms, and reasonable response dates. The third point, so I'm really big on making sure that we record and document all calls. So I always talk to my team about taking file notes and keeping them on file, particularly when we think something might turn litigious or it's a contentious lease issue. So I do recommend, if you are having phone calls with tenants, no matter how minor, if it's just a call and they say, I'm not providing you any information, hang up, in the worst case scenario, or you do have a more at-length conversation with them, take a file note that documents what you did discuss in detail, the date, the time, and it should accurately reflect the conversation. So remove any kind of bias in there saying, well, this is trying to shape it up to be a landlord argument. That's not necessarily, that's not what it's about. So just make sure you accurately record. And look, I've known of cases that have gone to courts where it's actually been the file notes that were referred to. The file notes actually link back to telephone records. So that's sometimes how much they are relied on at a later point in time if it does go litigious. And again, these laws, and I was talking to Tim earlier, but they haven't been tested. And obviously, whilst you have a legislation, case law helps guide how sometimes that legislation is implemented in a practical sense. So We do want to make sure that we're doing the right thing if this does turn litigious, but we're all just trying to navigate as we can. The fourth point, ensure any agreements are documented by a solicitor or lesser solicitor. Again, we want to make sure that even the tenant is represented, particularly if they're entering into new lease terms or even a new lease during this period. And use mediation for its intent, but ensure that you are comfortable with your compliance to regulations. So one call to a tenant and not engaging doesn't mean you then go to mediation. You've got to be able to demonstrate that the landlord has entered into good faith negotiations and that you have gone through a process and again, sent letters to say, okay, we understand you've applied for rent relief and formalise the process that again, you do have a document trail. And I do also know that there's landlords, as have we, creating forms with requests for information. The REI has had some fantastic guidance and documentation that's been issued. I know the REI team's been doing a lot of work on that regard, or in that regard. So again, make sure I always call it with my teams, crossing the T's and dotting the I's, and now more than ever, we need to do that. So then the regulation don'ts. So do not apply interest to impacted tenants. Do not action rent reviews to impacted tenants. Do not draw down on bank guarantees or securities. For impacted tenants, do not re-enter or take possession of the premises for impacted tenants. And do not seek to mediate without trying to negotiate and be able to demonstrate, back to my earlier point then. So that's largely it. I know, Tim, you were going to add some commentary around the outgoings point, perhaps before we flip to questions, because that's
I think you have covered it, taking the view that it is rent, and I agree with that. You also said at the front end, I think on your very first slide, that it had been drafted rather quickly, and I think there's a number of things within the regulation that proves that. But I think my team did send it out to those that participated in my presentation on Wednesday. But clause 6.1 and then clause 7.1 contradict each other in relation to outgoings. But I agree with you when you look at the regulation and also in the context of the code. I think you're right, and I think it is the appropriate way to go in relation to considering it to be rent.
Yeah, I agree, Tim. I think we've got to, in this kind of, when you do have a legislation that's drafted quickly, look, you might virtually kick me here, but I'm sure the government's trying to do the best it can to support all parties. Yeah, we do have to then just be mindful, like err on the side of caution or conservatism. And I think that hopefully then when this is washed up, that we've done the right thing, or at least demonstrated we've tried to. I think that's what's most important now.
Absolutely. Well, we do have a number of questions, as you would expect. Some of them I think we have covered, but they are coming in anyway. So let me just get some clarity. Can a breach of lease notice be issued to a tenant with historical arrears not caused by COVID?
So again, a caveat that you should be talking to your solicitor and getting guidance from them. But if it's pre-COVID and the tenant's not an impacted tenant, then you actually can pursue those arrears. Again, I think I referred to thinking about in the longer term situation, is there a way that, do you want to keep the tenant in the premises? And so I know in retail particularly, it's better to have occupied shop fronts. So do you want to, is there a way that you can negotiate a payment plan with them that sees them, even manage through this period? I also appreciate that, there's always going to be, I guess, opportunists in any case. If we didn't have opportunists, we probably wouldn't even have law. But we've just got to make sure that we separate the tenants that are generally suffering here from perhaps people that are being opportunists and trying to get out of leases, etc. And I'm sure that there's a large spectrum in the middle. So I always say, look, if we're, again, good faith, let's try and negotiate with them. If they do want to stay in the premises, they may just be looking for a way to walk away. Again, pre-COVID and not related to COVID, then you should be able to pursue the payment for those arrears.
Yep, okay. Now, there's a number of questions around tenants saying that the code doesn't actually require them to provide turnover figures. So if people are refusing to provide those figures, what do you do?
Yeah, so again, if they want to be an impacted tenant, perhaps they can provide the ATO confirmation that they are an impacted tenant, they do qualify for JobKeeper. Yep. I also think that it's probably not up to the landlord or the property manager to determine on a financial basis whether someone is financially impacted. Some property managers, some landlords might feel more comfortable doing that. It does provide extra context. But again, everyone's going to come to the party here. So if you are impacted, how are you assessing that you're impacted? most normally you're looking at your P&L or your cash flow statements and you can see it. So if you want to be transparent in a negotiation and you're hoping for an outcome from an understanding landlord, then hopefully can provide that information to them.
And if they still say no, I'm not required, and they're demanding, they're not paying rent, they're demanding it's just mediation, right?
Yeah, mediation. So, and again, from a landlord and property manager perspective, make sure you're sending letters to say, look, we kindly request that you provide this information. We're trying to understand your situation. We're trying to be understanding of the situation, determine how much rent deferral or rent discount we might otherwise be able to offer. And again, it's the niceties in the email, in the letters that you'll otherwise send. So to make sure that you kind of seem to be in good faith and not necessarily placing demands like, something like send us the information or we won't even entertain it. Like that's not necessarily going to reach the right outcomes. So make sure that we're all entering this into good faith and understanding of each other's situations.
Will owners who have not received any rent from tenants who have not met the criteria as being impacted look to give notices to quit after the 24th of October?
So sorry, what was that question? So if
they have the tenant's not paying any rent,
yep.
But they have not demonstrated that they are impacted, what happens? Do they give notice to quit after the 24th of October, or can they do it now?
That's a difficult one, Leanne, because the regulation says that you qualify. It doesn't say you've got it. So if you qualify for the job keeper
and if you
program,
haven't, this one's saying
you don't have to have it. You just have to have the capacity to qualify.
No, but if they're not, the question is if they're not qualifying.
So if they don't qualify.
I'm sorry.
Yeah.
I thought you said if they didn't have it.
No, if they're not qualified.
So if they don't qualify as an impacted tenant and they're not an impacted tenant, then if you can actually, the landlord can negotiate with them under other terms and sort of say, okay, well, is there other payment plans or deferrals that we can agree outside any code or regulation? And every landlord is in a different situation and has taken a different position on this. If they're still refusing to pay rent, and again, subject to confirmation from your solicitor, I would think that if they're not an impacted tenant, then you can pursue them for arrears.
Okay. Are your property owners, Linda, grateful for the additional services they're getting from their property managers and facilities managers, or are they just seeing it as part of the job?
Do you know what? They've been very grateful. A lot of the property owners I've spoken to have been absolutely amazing, and we love them as clients anyhow, so thank you if any are listening. But they've called me personally, or they've written to me, or they've posted even on LinkedIn about what an amazing job our team are doing. And nice. I echo the sentiment because I work with these guys every day and they make me very proud. Yeah,
fantastic. Alrighty, if the lease expires on the 31st of August this year and the tenant has received a reduction of 50%, 25% is waived and the other 25% is deferred over a 24-month period, and the tenant vacates on the 31st of August and doesn't pay the deferred rental payments, can we retain the portion of the bond to cover the amount he owes under the deferred agreement?
So I'd firstly check on the bond that you do hold. So is it a bank guarantee? Is there an expiry date on that bank guarantee? So the actual New South Wales regulation, and Tim, correct me if I'm wrong, given your legal background, but the New South Wales regulation doesn't provide for the 24-month minimum payment terms like the code does. So Tim, I don't know whether you had a comment on that one.
Yeah, no, that's correct. It doesn't provide for that. But it says in the code, in the regulation on a number of occasions that you should have reference to the code each time. So it's one of those situations like you spoke about earlier, where they've got a foot on the wharf and a foot in the boat, so to speak. And I think that your approach about taking a conservative view of this is probably the best one. And for that reason, I think they have 24 months to pay it. But unless they're prepared to give you some commitment in there that they will do that, and obviously if they're being given 24 months, one could assume that they would have to make periodic payments. So if they're not prepared to do either of those things, then I think that you'd be justified in having access to the bond and or the bank guarantee.
Yeah, correct. And as it kind of goes back to my point as well, if you're going to agree a term like that, then it's still a contract between two parties. Make sure you document it. So there's still an obligation for the tenant to pay despite it being over a 24-month period. But again, just check the security deposits or your bank guarantees to see if there's any expiry dates on those. So you've got an extra bit of guarantee in terms of if the tenant doesn't pay, then you can claim on that.
Yeah, look, I commend what you're saying here about file notes. Well, I do, Leanne. You know,
I knew you would. I was watching you nod.
I beat that drum constantly, and
File is your friend.
Exactly, your file is your friend, so you get to write in it. But you're 100% right. A lot of these things are going to become litigious, and when they do, you will be very, very grateful for your file notes. So, yeah, I think that is very, very good advice.
Yeah.
Linda, are you charging the lessors any extra for all this negotiation, or is it just part of your normal management fee?
Yeah, look, this is a very good question. So I know that there is. So we tend, if we're negotiating, say, a lease renewal or extra term, we tend to charge an extra fee on top of that. I'm sorry, I'm just losing my lights here. We tend to charge an extra fee on top of that. This is a bit of an extraordinary situation, and we're dealing with it a case by case. So some agreements have made much easier to strike in terms of our, again, even I was talking to one of the property managers today, and one of our landlords has just come out and struck the front foot and said, okay, this is what we're doing across the whole portfolio. There hasn't been a lot of negotiation. There's a lot of agreement from both their office and retail occupiers. So where we're not, we were kind of debating about whether or not we did. I think if something goes to mediation and you really need to make sure you're pulling together the documentation and the file notes, potentially. Yeah, I shouldn't say yes or no, but certainly we haven't so far.
Okay. If a tenant chooses to close down of their own accord, so they weren't impacted by COVID, what is the tenant entitled to as far as rent reductions?
So they've chosen to close and they're not impacted by COVID?
Yep.
I would still probably tread with a bit of caution here, because obviously COVID has caused them to close. And so again, I know they're not an impacted tenant, but it's like actually treat them like an impacted tenant because they've had to close because of COVID. Is there anything more the landlord can do to kind of assist during this period? I know some tenants are kind of taking advantage of it, even though they sit within larger organisations. So you can kind of hopefully weed out some of the opportunists between and the people that actually need genuine help.
Yep.
But if they're not impacted and they've only closed because they had a choice to close because of COVID, I would say that technically they were still impacted by COVID because, the traffic numbers have been down. But that's where you've got to look at this case by case. The landlord's got to consider their own situation. You've got to consider the type of tenant. You've got to consider the long-term relationship or even the previous relationship, and how you can, again, kind of reach an agreement together to be able to work through this period.
Okay. Tenants who've been forced to close, like gyms and yoga studios, can we defer 100% of the rent, or can we only defer 50%?
I think that you could defer 100% of the rent. So that really comes down to a landlord's decision as to what they want to do. Like the code provides, the code provides for a minimum 50%. But I would actually, if particularly landlords and gyms and yoga studios, etc. Again, they would fit within the SME in general terms, and they have been impacted by COVID. So again, if you can grant 100% rent deferrals, that would actually, like, we're kind of in a liquidity crisis. Those gyms aren't generating revenue to be able to pay the rent and other costs, and a lot of them are applying for JobKeeper to try and keep even their personnel paid and enrolled, so that when we hopefully return to work and normal operating environment, that they can continue to still operate as businesses. So if the landlord's able to, absolutely, I'm sure that would go down very well with the tenant.
You would think so, right?
Yeah.
Now, the $10,000 medium business grant, which is aimed at covering outgoings, would this be deemed to be revenue? And as such, would any loss in revenue include this government grant in order to minimise the lessor's losses?
Yeah, so this is an interesting question, and one that came up originally before any of this, in terms of some of the work that we do with clients before COVID and for the code and regulation. We actually sort of said to some tenants, well, look, we'll get your completed application form, but also just let us know if you're receiving any subsidies from anywhere else to help you pay for it. I think, in general terms, we should look at what we control. So we control the outgoings, we control the rent. So we should consider what discounts we offer across outgoings or rent. But then if you do agree any terms outside of the lease and it's documented, there might be a provision in there that says, look, if you have received a subsidy that's due to be paid to rental outgoings or offset against rental outgoings, then that should be taken into consideration by the tenant if we kind of get through this period and wash everything up. So I'm not familiar with that subsidy in general, but I would say actually, you know, sometimes we've got to work with what we have in front of us, which is our ability to amend the outgoings or the rent or discount, either or.
So how do we handle the rebates on rent versus the deferments on rents in our trust system? Are we better to leave them in arrears until the deferments are paid, or make the deferred payment another invoice amount and just move their rent date up to the next period actually due?
Yeah, and look, this is going to depend on, again, trust accounting requirements and your own owner's way that they want to account for these funds. So for instance, at Knight Frank, we've created COVID codes. And so we can actually identify where we're offering some of these rental discounts or deferrals. Bearing in mind some of these references and definitions are different across the states, and we run a centralised service. So we've had a lot of fun trying to navigate this ourselves. But I think, yeah, work within trust requirements and regulation and accounting standards. But work with your owner to understand how they want to recognise it as well in their own, you know, P&Ls and property accounting, you know, provisions. So yep. We've kind of taken a bit of a flexible approach to it, but ultimately ensuring that you're compliant with trust regulation and accounting standards.
If a lease option is taken up last year to take place with an increase in February 20, can that increase be applied?
So again, I'd go back to impacted or not impacted. Even if it was impacted, I'd say, well, actually the increase was in February and the regulation isn't backdated, so it's not retrospective. So you could apply that rental increase. Again, seek clarification from your solicitor always, but that would be my interpretation of a practical application.
This is just a follow-up question to one previously. What about a tenant that has not been forced to shut down but has anyway? What are they entitled to?
Again, impacted or not impacted, and I think we said that they weren't going to be impacted.
No, not impacted.
Shut down. Look, I would just try and enter the commercial negotiations in terms of payment of rent and when they may wish to open back up. You know, we saw a lot of even some of our major chain retailers deciding to close. But again, every case is case by case. I know that's kind of, it's really probably why the government's had so much trouble trying to navigate some of this regulation.
Yeah, absolutely.
There's so many different instances and so many different cases.
Leanne, it's a great question, I think, because people, there is an obligation on somebody to mitigate their loss when they're turning around to somebody else. So, I mean, if you had obviously 100% of your income prior to COVID, and now it's down to something like 30%, and you say, look, I just can't be bothered opening for 30% of my revenue, then clearly you've given up voluntarily that 30%, and then you enter into the good faith negotiations with the landlord and say, well, I've lost 100%. So the reality of it is, no, you've lost 70% and you gave up 30%. So that would be something I think should, if we are negotiating in good faith, come onto the table for that discussion.
Okay. Got a commercial property that has a tenant that has always been in arrears, and now they're saying COVID is the reason why they can't pay their rent. They've actually moved their stock out, but they won't hand over access because they want to move back in later. The owner wants to do a lockout on the basis that the rent was already behind prior to the current situation.
Yeah, so again, be guided by your solicitor, but if it's pre-COVID arrears, you can pursue the tenant for those pre-COVID arrears. So again, it might be the basis for resuming possession if that's what the landlord wants to do. But I would exclude anything post-COVID and probably err on the side of caution to say not just anything due post 24th of April, but potentially even anything due in February. So just be mindful of that, and it's going to be a bit tricky, but maybe even before you approach lockout. And there actually is a provision I did come across that said, you know, if you do go to mediation and the mediator may provide you with a letter that says you've mediated, it hasn't been able to be resolved, that means you actually then can take prescribed action. So if you want to err on the side of caution, potentially you might want to take that tenant to mediation. Again, make sure all your documentation is in line and demonstrates that you've acted in good faith and taken all the measures within your obligations through the lease. mediate, which I know can take time, but again, just to err on the side of caution. And then potentially post that mediation, the mediator may confirm that you can take a prescribed action. So again, there's probably two approaches. One might be just to take action for the period prior and you should be okay. Or if you wanted to be completely conservative, you could pursue mediation for even the part that's due now, and reference the part that's due prior, which may help your case as well, potentially.
Okay, yep, that makes sense. Are you still charging full management fees if you've negotiated a rental concession?
So our fees are based on usually resources allocated, and you could say that our property managers and teams are working 150% now, and we're not charging more, and nor would we, because obviously we're trying to help our clients.
Exactly. Yeah.
So we moved away from a percentage of rent model, not in all cases, but certainly our management fees have changed in the 1 or 2 cases where we still have some of those models in place.
Okay. Is the 24 months deferred from April 2020 or from October 2020?
I would say deferred from when you reach agreement for the rent that's applied. But if you want to use the regulation date of the 24th of April, that may work. But just consider, because some have some owners started looking at deferments from April rent, which is the one April, and agreement struck in March. But just have a look at what the necessary details of the case you're looking at, I suppose. Tim, did you have any comments on that?
Yeah, look, I agree. You can do it for whatever period the good faith negotiations end up resolving. Some people have already done deals prior to the regulation coming out, which will survive, I would have thought, unless they brought back onto the table for further discussion. But really, it's up to the parties to decide. There's no requirement in the even in the code, as broad as that is, to pick a date. So I think that's right.
So we've got 20 questions and 20 minutes. So let's just, I will skip through the ones that I think have already been answered. Can an impacted tenant ask for a bigger than 50% waiver, which we've said, yes, it's obviously up to the landlord, but should the landlord provide a financial statement if the request for bigger than 50% waiver is rejected?
That's a good question. I don't think necessarily. I think, if the landlord's operating to the minimum requirements from the code, I guess that's what the code's helping to kind of provide at least some guidance or frameworks on what that minimum is. So again, I think sometimes it's considered that, like in our portfolio, we have everyone from mum and dad landlords to qualified institutions, and each landlord is going through their own, requirements in terms of financing requirements and other expenses, etc. So everyone's in a very different situation, and hence, even if you have an impacted tenant and you're applying 50% of the rent, for some landlords, and again, no matter the size, that can actually be quite impactful. So I don't think there's nothing that requires them to provide their P&Ls and financial statements. So again, if you can try and agree a scenario, if they can provide any further information for the landlord to get more insight into why they're requesting a higher discount, then perhaps that might assist.
Health and hygiene will be concerns for building occupants until we find a cure or vaccine. How are we going to manage people heading back to work in relation to toilet facilities, lifts having fewer occupants, temperature checks, people that are sick being turned away? What are you thinking?
Look, that's a very good question. And I think all property owners and business and tenancies are all reviewing this at the moment. We've done extremely well in Australia in flattening our curve, and we want to make sure that it remains flattened and that we don't have this second spike like we've seen other countries have, which means we need to do more and all that we can to provide safe, secure and clean premises where we're sort of approaching on that basis. And so this does mean we've reviewed temperature checking at building entrances. And look, I am mindful that if you look at comparable countries like Singapore or some of our Asian counterparts that have implemented it, that has been under government regulation. We're still not sure if government will require us as building managers to do temperature testing. And again, then what the requirements of that are in terms of turning people away from a building. We don't feel like that's within our legal rights to turn people away from buildings. And that actually it's probably on the tenancy floor. That's where we're going to need some collaboration with tenants, because if they're doing the temperature checking at their level, they're monitoring their visitors that they've invited or that have turned up to their premises that they can turn away. That's one item that we're still exploring. And I think last week the government announced that there might be some code that will provide some guidance. But also I think that all businesses need to review how they'll return to work. And we're doing a huge piece around this. Actually, there's a shameless plug, a webinar from Knight Frank next week exploring this with some of our global counterparts. But businesses need to review how they might otherwise be utilising their premises and incorporating social distancing. So if you have your team sitting 1.5 metres apart, it may be that they're sitting at every second desk, or whatever your requirements are within and specific to your office. We're looking at the flow of individuals around an office, so that we're minimising the ability for teams to come in contact with each other less than 1.5 metres. We've been working in kind of flexible work environments for a very long time, and so even strewn through the Knight Frank office is a load of hand sanitizer and everything to clean down desks. That flexible work environment, I think, is being turned on its head a little bit, because people are looking at how they have their own workstation, keep it clean, and obviously know that they're the only ones that have touched it. It changes things in so many ways. And even on lifts, we've sort of been talking amongst building owners and other managers about how we navigate lifts as well. And whilst most lifts can only really incorporate or hold one person to maintain social distancing. But then you think about the overcrowding that might otherwise occur on the lobby floor. So we're looking at crowd control, similar to what you get at an airport, and some decals on floors to kind of highlight what 1.5 metres looks like. And even when you do, and I've still been, going to my local retailers, and people just aren't used to it. It's changing behaviours. So you've got to adjust the environment, but also you've got to change behaviours of people to sort of understand what that social distancing looks like. So there's a lot of work being done, but I think we're approaching it on the basis of make sure that we can provide safe, secure and clean environments for our tenants to return to, and landlords and tenants have got to collaborate together. Another point too is, I think we may still be working in a split team environment, which some organisations were doing before we sort of went into larger scale lockdown. And so that might come back at least as an interim measure, which will help tenants occupy their premises if they are sort of sitting a desk apart, or their teams are sitting a desk apart. And certainly we have proven, like any challenge, we've proven that we can kind of rise to it, because we can all work remotely and use the virtual environments and technology that's available to us. So there's a big piece of work to do there. But again, this is where landlords and tenants need to come together to resolve it. And there are some fantastic landlord and tenant relationships. So I have every faith. I'm always overly optimistic. Tim's smiling, but I hope it's not. Obviously, it's case by case. But I think that now more than ever we can collaborate to build solutions.
I can see problems in that space. I think that there will be arguments put forward that the contract is frustrated. Contract being the lease. As the tenant, I want to occupy the premises. As the landlord, you want me to occupy the premises, but you can't give it to me and I can't access it. So therefore, there is a frustrated contract and I don't pay anything. I can see those sorts of arguments being put forward. To stay with your example, the gymnasium, the gym owner say, well, I want to open, I want to have people in my gym. I can't, not my fault. So the contract is frustrated. I can see those things coming through. If the money is big enough, then you'll see that. There's also been buildings in the city, as I understand it, that have had people in them that have been COVID or do have the coronavirus, I should say. And then it's a question of how much remedial activity is required, reasonably required, in that building before you can say that it is good enough for people to go back into. And that's a very subjective question, and whether or not the parties will want to leverage that is yet to be seen. But I do see the possibility of it.
Yeah, and look, I think our response to COVID has kind of transitioned from responding to cases or reported cases in buildings to then responding to, we never really went into full lockdown where it was encouraged that anyone who could work from home around the states, and obviously different states had different requirements, and there wasn't a hard and fast definition of essential services. Granted, there kind of was Scott Morrison even said every business is essential, which confused things even further as we're trying to navigate who can stay open and who couldn't. And so I think that ultimately, as we transition even to rent reduction, now we're kind of like our accountants. So it's been our facilities managers, our property managers, and now our accountants obviously trying to account for all these changes in leasing terms and the financials. But I think we're going back to now reoccupation. We've got to consider, you know, there could still be reported cases, and because we've already gone through that, even in the first iteration, Tim, which was in March, we've got process in place and process with tenants that if they have a reported case in their building, they've got to make sure that that we've found that they tend to, you know, send everyone home, organise a hospital level deep clean of their floors, premises. We do extra cleans, which we're already doing as part of the common areas as well, particularly high touch areas. There's even been, I know, questions about, okay, air conditioning, filtration. Certainly the guidance provided to us by WorkSafe, you know, Victoria and other institutions, that, you know, filtration, as long as it's in requirements with Australian standards. So you are replacing filters in requirements with Australian standards. You know, buildings are safe and secure, and you know, COVID isn't transmitted via HVAC. Again, this is all based on some of the research and guidance we're being provided. It is a new virus, and certainly we're all trying to understand the information that's available to us. But I know that, and I'm sure some of our management counterparts, that initial response has already prepared us for the return to work if we have to go through responding to cases again with policies and procedures. I know that there was some fantastic stuff from the REI too, Tim, so thank you very much. Yeah, we just have to kind of work with what we've got. And I know a lot of businesses and a lot of tenants are really eager to get back into building.
Yeah, it's true.
With some of our
have you seen any growth in tenants reps getting involved in discussions?
Yeah, absolutely. And look, tenant reps and occupier representation is always something we encourage, because they become more qualified and informed along the way. So definitely, particularly as all tenants, like landlords, we represent landlords and try and navigate the legislation. You know, tenants are doing the same. So if two parties are represented, I think that actually makes for a better negotiation, because you know, we're always going to sound like we're biased to the landlord, and I guess technically we are, but certainly when they're represented on the other side, they're going to be biased towards the occupier. But if you've got two real estate individuals negotiating with an understanding of regulation and good faith, then hopefully you actually reach a better outcome.
Okay, I've still got lots of questions to get through, guys, so I'll combine a couple of them. Is it up to the tenant to slowly pay back the deferred amount over the 24-month period, or should we be organising a payment plan for this? And how do we then document? What kind of formal agreement should we draw up?
Again, depends on what you have agreed. So if you've agreed a deferment, incorporate that into the payment plan, looking at that 24-month period. You can, again, we tend to use Excel to calculate what that payment plan tends to look like even outside of COVID. But then also document, so by way of side letter, I've always recommend a deed more preferably, and again, drafted by solicitors, and ensuring that your tenant is also represented, so then understand what they're signing up to in that deed.
Okay, for tenants that have lost 100% of their revenue, like gyms, 50% is waived, 50% deferred, right? Not that 100% is deferred.
Yep.
That's correct.
The prescribed period starts the 24th of April. If people haven't paid April rent, even though they are eligible, they still have to pay their rent up until the 24th of April.
So I would err on the side of caution there. I would actually include April and potentially March. I know obviously if it's COVID related, then technically that could have started from March, which is when we really started seeing some of the pain in the response. So I would just err on the side of caution.
Yeah, the way I read the regulations, and again, they're not well drafted, but if they are COVID impacted, if that's what they are, then taking action, and as that term is known, I don't think you can commence proceedings or maintain proceedings during that period. So from 24 April through to 24 October, I don't believe you can do that the way it reads. Even if there was money owing, a breach beforehand. In other words, they hadn't paid their appropriate amount of rent. The only rider I put on that is that they must be COVID impacted and satisfy that requirement.
How do you determine when the right time to start charging full rent again is, and what documentation do you suggest that we ask for?
So again, I'd look at COVID impacted or not. We've got a prescribed period, that's in play until October. So look, I know that even with agreements that have been reached outside of the code or regulation with non-impacted tenants, some landlords are reviewing month to month. And again, there's already been some positive signs, again, of easing of restrictions so that we can sort of get back working and hopefully people can start attending shops again. So hence they've kind of taken a view month by month, hoping that we're going to be in a different place, month by month. So again, it is very case by case. So again, review, is it impacted, not impacted, and work from there.
That's a really good point you've raised here, Linda, because one of the questions I have is whether or not once you qualify and you come into this period and you satisfied it today, does that mean that regardless of what happens to your business, whether it recovers the following day and you're back to where you were, you are still in the process, or can you review it periodically? And that I believe is not a question that is answered well in neither the code or the regulation.
Yeah, and I definitely agree with you there, Tim. I think we are there's a prescribed period set. You never know, your tenant might turn around and go, hey, look, I'm doing okay now, let's kind of take a view on this. But the regulation does provide for a reasonable period even after the prescribed period. So you could actually say, well, maybe it's actually meant to be for a longer period potentially than even the prescribed, reasonably acting. I should say acting reasonably. So look, it is a very grey area. So again, if you can reach a commercial agreement, you've got to kind of, you both are talking in good faith, hopefully you can kind of reach an agreement, but knowing that if there is a dispute, you might just have to fall into that prescribed period and potentially a reasonable period afterwards.
If you waive outgoings and the landlord gains a land tax benefit, which is part of the outgoings already being waived, do you still credit the tenant with the land tax benefit?
Look, if you're waiving outgoings, tenants pay a proportion of outgoings based on the area that they occupy. So if you're paying land tax, which is one item in outgoings, there's plenty of others, including the standard operation, normal operations of buildings. And buildings we've had everything from buildings operating at 100% still to, 10% occupancy sort of thing. So, in all cases, we've still continued to run services because that's, what the lease obligates us to do. We've tried to do it in a smarter way where we can identify savings, etc. So if you've discounted outgoings, then you're going to receive a potentially 25% discount from land tax. Then you can look at the land tax item on your budget or anticipated outgoings and discount the 25% against that to then work out the tenant's proportion of that discount, because that's certainly going to be how you're going to wash that up at the end of the outgoings year, assuming that the land tax is paid and credited through the payment of those outgoings. So, the landlords could receive a direct subsidy from outgoings, and then we have to direct subsidy from land tax. We then have to look at how that then is then applied to the tenant because of the obligation to pass that through. So the conservative position is, again, if you collect outgoings for a financial calendar year, you are obliged to reconcile that at the end of the year and send back any money that you haven't spent or ask the tenant to pay any money that you have overspent on. So if you're already discounting the outgoings now, then that may then at least anticipate a discount that's later provided that then doesn't need to be provided by the landlord because you've already discounted it and you've actually then reconciled in terms of what you paid versus what was due to be paid, if that makes sense. So.
Yep. All right. We've only got a couple of minutes left. Deferred payment of 24 months. Does that mean in April 2022 we can ask for the full amount owing, or they start paying arrears in April 2022?
So deferred amount, that would actually be paying the deferred amount in April 2022. Correct me if I'm wrong, Tim, but I think that's kind of, you're deferring it for an amount of time, or if you're discounting 50% and then deferring 50%, it's like, well, looking at what you're deferring for that 50% out to 2022.
Yeah, so it's a great question because it doesn't actually say that they have to make monthly payments. I think it's inferred that you don't. It has to be a minimum of, pardon me, it has to be a minimum of 24 months or the remainder of the lease, whatever is longer. But again, if somebody wants to argue, well, I'm not going to give you the money until the 24th month, it's an argument, but it's inferred, I believe, that they would be paying it monthly.
Yeah, and like at least a contribution of, but again, in the simplest terms, so some of the agreements we've struck are, they deferred 3 months, and then they're going to defer them to the end of the lease. So at the end of the lease, they'll pay 3 months. So it's a different situation scenario for every landlord and tenant. So, and it's not hard and fast in the regulation too. So try and work out what the easiest position is in terms of cash flow for the landlord, like how much pain or how much allowance can they provide for in terms of deferment, and then try and negotiate again with the tenant to work out what that payment or deferment looks like as well.
Yeah.
There's been a few questions asking the same thing. If tenants have lost all of their income, how can they afford legal advice?
Yeah, again, if they want to roll the dice and if they're comfortable, I always recommend legal advice, and I'm sure there's plenty of solicitors with varying fee structures that might be able to assist. And I know not everyone can afford legal advice, but again, it's like, when you purchase a house, you make sure you get your conveyancer to represent you to ensure that you're signing a contract that's clear.
A lot of legal documents will say that you had the opportunity to get legal advice. So just to point out, it wasn't denied you. I know it doesn't answer the question, but nonetheless, I think it's important to have in the documents that you had an opportunity to get it. Now, whether you chose not to get it or couldn't afford to get it is really on your side of the fence.
Okay, well, we are at time. I did just want to say that I did get a message saying Linda is incredibly calming amidst the complexity in the commercial sector. She exudes, take a breath and carefully assess each case before acting. So thank you very much.
Oh, well, thank you very much, Dawn. Thank you for inviting me to take part, and hang in there, everyone. We'll navigate this together, and we'll come out of the other side of it.
And if there are any questions that you don't feel were answered during that presentation, by all means send them through to us. But bear in mind, we will give you access to both the slides and to the recording so that you can go through it again. Okay, thanks everybody. Take care.
Thanks.